As a licensed private investigator, many times we get questions from clients and the public about what a private investigator is and what can be done under the license of a private investigator. Here's the top 10 questions that we get about being a licensed private investigator. The most common question is, can you carry a gun as a private investigator? And even though the license for private investigator gives some additional authority over normal civilian activities, carrying a firearm is an additional license that's required. We'll talk in a minute about some of the other privileges that a licensed private investigator has, but carrying a firearm is a separate license or credential. And in most states, in addition to your private investigator license, you'll need a special firearms carry permit. Now, this is different than a normal concealed carry permit or a normal civilian concealed weapons permit. And the reason why it's done differently is because as a civilian concealed carry holder, the governing agency figures that you're not likely going to be involved in a situation that you're going to need to use your firearm. It's probably going to be rare or unlikely that's going to happen. With a licensed private investigator, the chances may be higher that if you're on duty and you are carrying a firearm, that it's more likely because you might be in more dangerous situations than just a civilian. As an example, in the state of Florida, if you are a civilian, you can get a concealed carry permit or concealed weapons permit as a civilian. Even if you have that permit, if you're a licensed private investigator, you cannot carry a firearm on duty unless you have an additional license, which is called a G license. This requires additional training and annual recurrent qualification for your firearms license. You have to go on a regular basis and go through a certification course to make sure your license stays up to date. So a firearm carried on duty is a different event than just carrying a firearm as a civilian on your day off or when you're not working. So that's the gun question. The question number 2 is, can a licensed private investigator arrest people? Do you have a power to detain and put people in detention? And in most states, there is no difference with the power to arrest, citizens arrest, for a private investigator and a civilian individual. There's some states that have some additional allowances for a private investigator to perform an arrest in part of their duties, but they immediately have to contact law enforcement. You can't go out looking for crimes to arrest people for. If as part of your duties as an investigator, you witness certain types of crimes, you may be able to detain somebody. But in most states, it's very similar or exactly the same as whatever arrest authority that a private civilian either has or does not have. So that's not what private investigators are looking to do. They're not looking to arrest or detain people. They're looking to investigate and obtain information. Towards that end, what about asset search, asset recovery? Well, what can a private investigator do for assets? This is the most common type of case that many investigators work on, is looking for hidden assets, looking for recovery of funds through a scam. Maybe the client has a judgment against a third party and they want to find those assets so they can get their money for their judgment. And the private investigator will do an asset search. And it's not a simple electronic push a button, pops up on your screen. You're going to have to go through a lot of documents and review different records and do forensics on financial documentation. And the result will be an asset search. It'll include things like bank accounts and real estate and vehicles and all types of different asset classes. So asset searches are an important part. Now, recovering the assets usually requires an additional legal step called a writ of garnishment, meaning that once you've located the assets, before they can be seized, like taking money from somebody's bank account, the court needs to sign off on those assets to say, yes, these assets are eligible to be seized for this debt. Because otherwise, anybody could just go around grabbing anybody's assets on a say-so. So typically, an investigator will sign a licensed investigator report. Here's the assets, here's the subject. It's submitted to the court under a legal process. The judge will sign a writ of garnishment. This can be done without the debtor or the subject knowing that their assets are under review. And then the assets can be seized either through bank seizures or maybe taking a vehicle or putting liens on property. Number 4 question we get quite a bit is, can I get a job as an investigator? Will you hire me? Can I work for you as an investigator? Close to 50% of the clients we work with always ask the question, can I do work for you? I already did a lot of research on my case. I know how to do records research. I did a lot of preliminary investigation. Can I work for you? Do you have any job openings? Well, like any other profession, there's opportunities for people who are smart, who can think on their feet, who are clever to be in the investigative industry. A couple things to keep in mind. One of the requirements is just a market requirement. Is there work in a certain business for you as a new employee? Not every business has extra work to take on new employees at any given time. The second thing is it does require a license. So if you are going to be a private investigator and work for an agency, you'll need to get a license. And the licensing process in most states requires that you have a certain number of years as a observed or managed intern, meaning that you have to work under the supervision of a company or a manager for a certain number of years before you can have your license. So you'd have to find an agency who's willing to have a person not only take you on as an employee with that expense, but also to have somebody that can train you for that 2 years, which also requires other investment of time for that company. So certainly there are opportunities, but it's going to be something that requires a commitment and a long-term plan for this as a career, not just a temporary part-time thing. Another question we get quite a bit is, can you secretly record phone conversations? Can you tap into phone calls? Can you listen in on different observations of people talking to one another? And the easy answer is normally no. Most states have laws that prohibit covert recording or even monitoring of private conversations, whether it's by phone or even in person. If there's two people talking across the street, most states have laws that you can't use listening devices to magnify voices. Now, some states have what's called a one-party rule, meaning that as long as one party to the conversation acknowledges and agrees to the recording or monitoring, it's okay. Most states are two-party states, meaning both parties have to be notified they're being recorded. So secret conversations, in most cases, can be kept secret, and if you violate that rule, not only can the recordings not be used for any purpose, but you can get in trouble for doing that. Another question that comes up is, do you do a lot of surveillance? How do you do surveillance? Well, surveillance obviously is the stereotypical activity you see on TV shows and movies. Investigators, with cameras or telescopes monitoring people, right, doing surveillance. And certainly that's part of an investigator workflow, daily routine. But that's only in cases where you have to monitor the independent activities of a person. In most cases, investigations can be done using document research, analytics, digital forensics, which we'll talk about in a minute, mobile devices and technology device investigations, where independent surveillance following somebody is not as common as it once was, because in most cases you can get that information through other means which are less time consuming. To follow somebody around for 8 hours can get very expensive very quickly, where you might be able to spend just 2 or 3 hours of electronic research to find out the same information. But it does in some cases become required and necessary to do surveillance, and it's important it's done correctly, because surveillance can turn into stalking very quickly if it's not done correctly, if it's not done properly, knowing the laws of the state. Sometimes, if you do surveillance and you watch somebody even through the window of their house, that can be illegal because they have an expectation of privacy. If you're the counterparty or a related party to a person and you do your own surveillance, that could be taken as stalking. Even if you're an investigator if you go out of your way to make yourself conspicuous, to make yourself be seen by the other person, to try to scare them or rattle them, that can also be construed as being stalking rather than covert surveillance. You have to be very careful how you do it. Related to surveillance is GPS tracking. That's another question we get. I think it's question number 6. Can you track somebody's location using GPS on their car, on their phone? And again, in most cases, the state law in all 50 jurisdictions will say no, you cannot independently or secretly track somebody using GPS on their phone, slap a GPS on their car, use some type of, Apple device or chip device to track them. Now, there are some exceptions. If you own a vehicle that you are tracking the vehicle for purposes of safety and security, and the person's in the vehicle, that may be allowable. But even in cases where the vehicle's owned, if it's shown that you're only tracking the vehicle to monitor a person's activities and not for any legitimate vehicle risk purposes, then it's going to be thrown out as being something illegal and you're harming that person. In most states, you have to actually notify a person if you're tracking their vehicle. A lot of employees have vehicles that they drive that belong to their company they work for that have a GPS tracker, and they have to be notified that it's in the vehicle. What about digital forensics? This is question number 7. Can you get information from a mobile device or a tablet or from a computer? Yes, that's a very common type of investigation, to do data extraction from electronic devices. In fact, even deleted records can still be extracted from phones or computers. Hidden picture files, voicemails, documents that have been wiped from the device, and many times can be recovered using multiple methods. Sometimes methods from flash images that are on that phone, ghost images on the phone, sometimes from the cloud has a copy. Remember, every document, map location, prior history, phone calls, text, don't just exist in one place on that phone. And when you delete it, the other backup copies may still be there, and there may be copies on other devices that can be brought back into that phone. So digital forensics is very valuable and often overlooked as a tool by clients to get information that they need that can help them with their case. Another question is, can you work on contingency, meaning that if there's a case that involves a financial recovery or asset search, can you work as an investigator and just get a percentage of what is found or what is recovered? Or maybe on contingency, if you have a divorce case and you say, well, if you catch them cheating, I'll pay you a percentage of, or a bonus fee. Almost every state in the licensing requirements for investigators prohibit contingent payment agreements. It's not like an attorney you see on TV that says, we only get paid if you win your lawsuit, or we get a percentage of your judgment. Some attorneys are allowed to do that for certain types of cases. Even in the legal industry, you can't work on contingency in most types of cases, only certain types of cases. But in investigations, the law specifically prohibits contingent fee payment arrangements. And here's why. Because a private investigator is supposed to find true and correct records and results. If they have a vested interest in the results going one way or another, they might be inclined to fudge the results or make something up, or even coerce somebody to do something or say something that will help them. And the state laws recognize that some investigators that would be unethical might do that. So they put it right in the law that says, can't work on contingency. You either get paid or you don't. The other reason for it is because even if there was an allowance, no good investigator is going to work on contingency. Because if you're an investigator and your agency is going to put 10, 12, 14 hours into a case, if you don't know you're going to get paid, nobody working on that case is going to put their heart into it. They're not going to say, well, I'm going to go 100% into it, because as an investigative agency, you don't know what the results are going to be until you get done. So if somebody says, I have a judgment of $200,000, I need to collect the judgment. If you find the assets, I'll pay you 30% of my judgment. Well, How do you know the person even has the assets to satisfy the judgment? What if you do an asset search and they have no money, or they only have $10,000? You're not going to know that their ability to satisfy that judgment exists until you get done with the case. By that point, it's too late. So there are some investigators we've seen that'll say they'll do it on contingency even when they're not supposed to, but they'll just put a very small amount of work to see if it's going to be an easy case. And if it's easy, they'll continue. If it's going to be any kind of difficulty, they're just going to bail and forget about it, because really no quality professional investigator is going to spend a lot of time working on something that's not a guarantee, because we have other cases to work on. We have plenty of paying customers that want work, quality work that they're willing to pay for. So there's no reason to drop that to work on something on a speculation. The last question that we get quite a bit is, do you have to notify the cops? Do you have to involve law enforcement with cases? And in most scenarios, no. A private investigator does not need to work with law enforcement. You do not need to tell the police that you're working on a case. In fact, almost all states have a requirement that you keep your case information confidential. You can't tell any third parties. You can't tell the police unless there's some imminent threat to somebody, or your client is, threatening to murder somebody. You can't tell police what you're working on. Now, there is an exception to that. If you're working on surveillance and you're going to be parked outside somebody's house or parked down the corner, sometimes it's good practice to notify the local jurisdiction for law enforcement to say, look, I'm a private investigator. Here's my license number. I'm going to be at this location doing static surveillance on a location. So if you get anybody that calls up and says there's a weirdo car, suspicious vehicle parked on the corner, that's me. That way they have it on file, so they're not going to come, pull up next to you, put the lights on, and it's going to blow your coverage of the surveillance. So you don't have to notify the police, but sometimes it's good practice if you're doing surveillance or something where police could get involved to notify them ahead of time, so that way you have that good working relationship with the local law enforcement and the jurisdiction. And along that line too, the other question is, when you are working on a case, what happens if there's evidence of a crime? Well, unless it's a imminent crime that's going to happen, or that you're required to under law, like certain child endangerment scenarios, then the law says you can't notify a third party. You have to keep it confidential unless your client does something wrong, either violates your contract, doesn't pay your bill, or does something to breach the contract, or the client gives you permission to do it. You can't force a crime to happen either. One of the types of requests we get a lot is somebody says, look, I know that my ex-spouse goes out drinking, and so what I want you to do is, when he's leaving the bar, bump into his car so he gets a DUI. You can't do that. You can't force a crime to happen. And that's going to come out very, very quickly, and everybody's going to get in trouble. You're going to get in trouble as a client for making this happen. The investigator will get in trouble. So you want to not force crimes to happen. And the last little bonus thing we'll tell you about is, if you're working with any kind of litigation, you have a court case, a lawsuit, a divorce, a probate, if you have an investigator, have them look at what activities the other side is doing. Many times, the other side to your case, the counterparty, as it's called, will be doing things, even with a private investigator, that are illegal. Sometimes the investigator doesn't know about it. 30-40% of the time when we look at a case, we look at what the other side's doing. We find stuff they're doing for investigations that is illegal. Maybe the way they're doing their asset search is violating privacy laws. Maybe the way they're communicating with third parties violates court rules. So there's a lot of things an investigator can do. In fact, sometimes if there's a deposition in a case, or a testimony in a case, as an investigator, we can watch that deposition or watch that testimony and very easily see lies that are being told, or things that maybe the attorney can follow up with additional questions to prove inaccuracies in testimony. So there's your 10 questions for a private investigator. If you have other questions you'd like to ask, put them in the comments. Or you can email us at Active Intel, and we will put them in our next video to answer the questions that might be of interest to find out about from a licensed private investigator.